Go for the big intro.
Big intro. Welcome. It's Mark and Richard here from Cubed Consultancy, and today we've got the award-winning Steve Bish with us today, who is a wills expert and estates. Welcome, Steve.
Thank you very much for having me.
You're welcome. You're welcome.
Estate planning practitioner, I think, is the.
Oh, that's the official title.
Is that the award or is that the certificate?
No, I've lost count of the awards.
Oh yeah,
we don't talk about them very much.
It's a joke. No, it's gone out of control. So, how did you first get into it? What was your journey? We'll talk about that first. And
I'm actually putting a chapter together for a publication about why the managing director and founder of a joinery company, which I was, packed that all up and went into estate planning. And the story it's quite a sad one actually. It's my best friend. We were fellow members of a vintage scooter club. I was on my Vespa, he was on his old Lambretta. We had a ride out. He never made it home. He was hit by a dangerous driver after leaving the rest of the group, and he never saw his 19-month-old daughter again. He was killed outright, and I saw what the family went through with the rules of intestacy. You know, chap in his 30s, didn't have a will, and it was a nightmare for the family. It just added to the loss in general. What Anne, his widow, had to go through.
But were they married?
They were married, yeah. So it wasn't as bad as it could have been with the rules of intestacy, and the business, the Real Wooden Window Company, as it was. I was looking for an exit route anyway. It was during the Blair Brown years, where the old days of fax machines, and you'd get a new regulation or a new law sort of appear on a fairly regular basis, and it was. I just saw an advert, I think, in one of the papers for retraining, get your qualifications. I went up to the northeast, spent a few weeks studying, sat the exams, and here I am, 20 years later. So.
Wow. So what was the time period between your sad loss of your friend and starting? Couple of years.
Yeah.
And why the northeast?
Because that's where the that particular training organisation was.
So you weren't living up there or working
no,
up there?
no, it was a case of getting the train.
Soft southerner like us.
Soft southern, shandy drinking, whatever the rest is. So, I'm from Huntingdon originally, Cambridgeshire.
Oh, right, nice.
Based now in Welwyn Garden City.
John Major's country, isn't it?
That's right, yeah.
So how difficult was it for Anne? What was the process? I've never experienced it myself.
We're losing a husband at a young age with a young child is going to be difficult anyway, no matter what preparation had been made. But the fact that there was no preparation, no planning, just made it so much worse. Yeah. And as Richard alluded to, at least they were married, so at least the bulk of the estate went to her anyway.
That's automatic.
It's a little bit different now, actually. If a married person dies intestate, the spouse will receive the first £322,000 and all of the personal possessions. If there are children, the balance is then split 50-50. So if there's 3 children, for example, they will share half of what's left, and the spouse will get the other half. So the bulk of it goes to the spouse. Yeah.
Yeah, because they used to say, didn't it? It was like the rule of the cross. You know, it goes sideways to the partner. It goes down to the children, then ultimately, if no children, it goes back up to the parents.
Yeah,
if they're
spectacle,
still alive.
Testicles, wallet and watch. Yeah,
and it's still the same, yeah? Give or take, apart from that limit on the 325.
If there's no spouse, then unmarried couples are entitled to nothing. They have to make a claim, and they might or might not be successful. But if it's an unmarried couple with children, everything goes to the children. Unmarried couple or single person with no children, if they have parents alive, it will go to parents. After parents, if they're not around, it will go to siblings. And then it starts to get a little bit more complicated with full blood aunts, uncles, full blood cousins, half bloods, and it does.
Yeah, because my mother, her partner died and they weren't married.
Right.
And there was a number of 6-figure policies paying out that instantly had 55% seized from them, so that was a hard lesson to take from her. But she's now passed away as well.
How long is the process when it does go into that situation where there is no will to get funds?
Well, the thing is, even if there is a will, it takes so long these days.
It does,
before COVID, if I had a will that wasn't contentious in any way, we would get a grant, usually within 12 weeks. Now, 12 months is not unusual.
Wow.
I always say people who we're applying for probate on their behalf, allow 9 to 12 months.
And that's just backlog, is that?
It's a backlog. Sometimes there's reasons. Sometimes it's not as straightforward as we might appreciate, at first glance.
Yeah.
For example, we had one quite recently. There was a professional executor who had emigrated to the Philippines and refused to renounce. So that one actually took 2 years before the beneficiaries got what was due to them, and it ended up with the courts declaring the executor a hostile executor, which was new to me.
What would you say? Like, my mother passed away a couple of years ago, and I sent off the checks, requested, paid extra for more probate grant certificates, and then nothing happened for like 6 months. Chased them down, and then the same thing. Oh, we haven't got your original estate summation form, where you estimate the capital gains tax, or the inheritance tax rather. And then that went round another cycle, and then I had to reapply online, and that took the best part of 18 months. Is there any way of breaking that deadlock, or is it
Unfortunately, no. It's very much the luck of the draw. I'm on several legal forums where people are talking about similar cases to what you're describing there, and it really does seem to be a lucky dip. Some cases, they're still saying that the average is much lower than what we know the average to be. So there are cases out there that do get done in 12 weeks, probably. But they're very few and far between.
Yeah, we had a client that came in, sat in this room actually, and his mother, his mother passed an apartment, and he did, to be fair, get it within about 3-4 months, and everything seemed to flow quite well. But that seems to be the exception rather than the norm. But anyway, that's more process.
It certainly is in my experience lately, yeah.
So you wouldn't be surprised.
Certainly since COVID.
But you wouldn't be surprised of a 12-month or an 18-month. It's just the way it is.
It is.
Unfortunately.
It is. It is what it is, as they say.
Well, that's at least a little bit reassuring. So,
no, I don't think it was anything that you did wrong. It was just one of those cases.
Well, with a sister and 2 sons, grandsons, there's been questioned that it doesn't take that long, and I'm going, it can do. So
yeah, definitely can.
I appreciate that.
Are you surprised at how many people don't have wills in place and power of attorney? I know you talk about the importance of that.
Yes. 20 years ago when I first started, I think the figures were, 67%, 2/3 of the deaths in this country were classed as intestates.
2/3?
Yeah. Wow. But it's not much better now. It's still well over 50%.
Really?
Depending on which report you believe, anything from 51% to 62%.
But your experience would support 60% or not having a will?
Yeah, or not having a valid will. Very often, we get rung up for probates, and I explain what's needed: death certificate, national insurance number, tax number, proofs of ID, the original will. And I can think of one case. Yes, Steve, I've got that in front of me. I'm looking at it now. What I should have said was a will that's been signed and witnessed, because when I looked at it, it hadn't been. So
that's a common.
It's more common than I'd like. Yes.
And so
if I'm not storing a will for now,
to be a valid will, at the very least, signed and witnessed.
Signed and witnessed.
So
yes,
these
definitely.
stories of on their deathbed scribbling on a piece of tissue paper. Oh look, this is effectively.
That could go to court, and it could be classed as a will, but it's not automatic. No.
Okay.
And how regular should you be updating it?
According to the government website, you should be looking at updating it every 5 years.
Right.
Sometimes it won't need updating. Sometimes it will.
Yeah.
And there are certain things which will invalidate a will automatically, such as a single person making a will, then getting married. That's automatically the will's revoked. And unless it's a couple, for example, an engaged couple who are making a will, they're mentioning each other in the will, I can put in there a contemplation of marriage clause.
Oh, right, okay.
So it remains valid on marriage.
It remains valid, yeah.
Okay.
Yeah, that's the paragraph that sort of explains that, yeah.
And the power of attorney, I know you talk about Martin Lewis and he's had a
Good old
positive
Martin
effect
Lewis,
on,
yes.
on your business.
Before COVID, it was very, very unusual for someone under sort of 45, 50 to inquire about a lasting power of attorney. But now I've got people in their 20s ringing up wanting it. And I think it's the double effect of COVID, all of us, realising our mortality, plus Mr. Lewis, he's almost evangelical about them, isn't he? So
almost as much about fixed priced energy cap that I saw him almost going to church over the other night.
Yeah. You had one in place for your mum.
Yeah, no, I was going to say, I had, two power of attorneys over healthcare and over financial assets, and it had been made when my mum was compos mentis, 7 or 8 years before her death. As when you make them, you go, you're going to be here for years and years and years, and then within 3 years she developed dementia. And within 2 years of that, then she died.
Yeah.
So what that enabled me to do was not to be beholden to the inefficient probate process, because, she moved from her main home, liquidated that, then for a period was paying, care home charges, which, as we all know, are significant. And just as you're starting to concern yourself about running out, you have a diagnosis, she has an end-of-life experience, and you've kind of anticipated that, and so you are actually, everything is more or less in your hands rather than beholden to other people. And I found it absolutely invaluable, because I was able to facilitate the move from her home into a care home. I was able to make sure she always had sufficient, things around her. If she wanted to do extras, it was being done, but with her resources, which even emotionally, it still gives her a sense of, independence, which was important. So, I would 100%. It just made a very difficult time. Not subject to just basic process mistakes. It meant you could concentrate on just enjoying, the last few years of her life, which was very.
They
important.
make things so much easier. So much
and
easier.
simple to do, of course.
Yeah.
Really difficult with the banks, though. I know how difficult they are to even speak to on the phone, but for them to acknowledge a power of attorney.
Well, my mother had about 10 main asset classes, from her house to shares, to bank deposits, to NSI bonds, and everybody, I have to say, all the banks had their own, bereavement departments, and they were all very, very supportive, with one exception, and the one exception was the share registrars for her listed equity investments.
Right.
So trying to execute a sale of some BP shares, some Shell shares, and some United UK Power Network shares is still ongoing. Really? Everybody else, the best was First Direct. We're not sponsored by First Direct, by the way, but every bank fell into line within, I would say, 3 or 4 days, which was impressive, I thought.
Oh, wow. That's great.
This was after the lasting power of attorney was registered, so it wasn't after death, it wasn't the probate situation. Obviously, the way I like to describe it to people is the will make sure your wishes are carried out when you die. The lasting power of attorney will make sure your wishes are carried out while you're still alive, if you lack capacity, either temporarily or permanently, to make your own choices and decisions. And they do just make life, speaking from personal experience, as you are, Richard, they just make it so much easier. And if you haven't got one, and you need one, as Mr. Lewis says, it's not something you can get at time of need. So the route that the families have to go down, if there is no LPA in place, they have to petition the Court of Protection, they have to apply for deputyship as opposed to attorneyship, and that's a process which is very, very long and drawn out, and you're looking at thousands of pounds to do that rather than hundreds of pounds to do a lasting power of attorney. So
I think from memory it was something like £750 to execute both power of attorneys, and it was done in a 90-minute appointment with a solicitor. And that actually did involve at one point me being asked to leave the room.
Yep.
So that the solicitor was convinced that there was no duress.
That's right.
This was her free will, and then I was allowed back in, and then it was executed there and then. And then it's literally, you put it in the drawer, and when you need it,
that's it.
And you never expect to need it, but when you do, it really takes a lot of emotional
You hope it's a waste of money, but it's a godsend if it's needed.
Yeah, exactly.
So that's one of the biggest pitfalls. What else have you seen from people?
Apart from unsigned wills, that's the common one.
Well, that's just
is that really
being
common?
Prepared, isn't it?
That's actually quite common, is it?
Yeah, what I've started to do now, because if people are storing their wills with us, then obviously we check,
of course,
we make sure that everything's executed properly. But if they're not, I've started a process where I ask the client to scan the signed attestation page, so I can actually keep a copy of that on file.
Yeah, fine.
And I know I've a little bit of CYA basically.
Yeah.
But it's been done then.
Nice. And in terms of the business itself, is it still growing? Yes.
Only really
still
when
dying?
people are always going to die.
Yeah. I suppose so.
It's like funeral directors; they're always going to be needed.
There's always going to be work for it. Okay, right. And what about the pains you've suffered as a business in terms of growth and starting out, I guess, as well?
Well, I only started the business. I was working for other people. When I first qualified, I was either working independently for other people or running other companies.
Just remind us, how long ago did you start?
20
roughly?
years this year.
So 20 years, and the majority of that was for others.
Yeah.
What qualification do you have to have?
It's unregulated, so technically.
Oh, right, okay.
You have no qualifications. Anyone can call themselves a will writer.
Right, okay.
I would never suggest anyone deal with anyone unless they're part of a professional body.
Yeah, of course. Yeah.
So I'm a full member of the Society of Will Writers and an independent member of the Best Foundation. And then SILEX, which is the Chartered Institute of Legal Executives, have taken over the Institute of Paralegals, of which I was a fellow of. So, you can always check people out. And if they're not a member of a professional body, why? Why aren't they?
It's a bit suspect straight away.
Absolutely.
Yeah, nice. And the business itself, how long has that been going for you on your own?
Started as Bish Estate Planning back in April 2022.
Okay, right.
So just coming up for 3 years.
So on the coattails of COVID, really?
Yes.
Not before?
No, I was running it was a financial services company who also had a will writing division, and I was asked to take that over, run that, and that worked out quite well. But then COVID came along. After COVID, I just thought, well, why am I doing this for someone else when I could be doing it on my own?
Did you have a client base at that stage or of your own? No. So really started out.
No,
fresh.
I made the conscious decision not to cold call, because we didn't cold call the other company was running, but there was an accountant above us, half a dozen financial advisors alongside me, so the referrals were there.
Yeah, of course.
And it is a referral business, pretty much like yours.
Well, exactly. I mean, that's what brings on to where I met you at BNI and networking. So how important has that been for your business?
It accounts for probably 75-80% of the business.
Wow.
It really does. Not just BNI, there's other networking groups as well, but BNI is obviously the best one. It's in my opinion, it's more structured. There's lots and lots of training, and as you've done, you can take that training into other networking opportunities, and it's
but that will writing element is your core business.
Yeah.
So if you're looking at what you earn in a year, it will be like 90% of what you do would be will writing, or not that high.
Everything is estate planning. So whether it's wills, trust, lasting powers of attorney, that's 100%.
But not everybody who comes to you will want, a trust or estate planning.
They might just want a basic will.
But everybody who comes to you will at least require a will.
Absolutely. Yeah.
On the trust, I mean, that's something that we always get asked about, is trust. When do you advise someone to go down that route, or are you given advice, or how does it work with your customers?
If you've got a married couple with children who own a property, I would say the very least they need is a will trust.
Okay.
So a trust that's in the will. There's lifetime trusts as well, which by definition they start during their own lifetime, rather than a will trust, which starts on someone's death.
Right, okay.
So it depends on the circumstances. There's no one size fits all. It depends on the individual, needs.
Yeah, of course.
Unfortunately, a lot of people think these trusts are magic wands that will just do away with inheritance tax, and that's not the case.
So
they can help.
What's the main benefit then? What's the main benefit for those folk who look for a will trust or
for a will trust? Could be anything from looking after children that are under 18. It could be a discretionary trust for a vulnerable beneficiary. The most common is a protected property trust, where a couple own their property jointly. They sever the tenancy, so they own half each as tenants in common. That allows me to put a protected property trust in both wills, and whoever goes first on that death, half of the property is already in trust for the children. Children don't physically inherit anything until the second death, but it does protect that half of the major asset in most cases. So it protects against a remarriage, it protects against care fees in later life.
So in that situation, it would protect against remarriage for half of the property?
Absolutely, yeah.
Right,
yeah.
Okay.
Yeah. But then the other sort of trust, a lifetime trust, that has multiple benefits. It makes probate a lot easier. It will do away with generational inheritance tax. It won't stop inheritance tax at that first level, as a lot of people want to believe. It doesn't. But
Could you explain that a little bit more? At what level? You say
if you put something into a lifetime trust, there are people mistakenly believe that will do away with inheritance tax. It won't. What it does do away with is that inheritance tax being paid again on the same asset the next generation down. It's one of the big arguments against inheritance tax, isn't it? It's things are being taxed that have already been taxed time and time again. So if you pay 40% on your mother's estates, and then you pass it to your children, and they're paying 40% on what you've already paid tax on, it's just generation after generation are paying tax on the same thing. So a lifetime trust can stop that.
Well, it can?
Yes.
Yeah. Okay.
Yeah. As long as it's written correctly.
Yeah, no, that's what I mean. But it's not like, as long as it's written correctly, it will stop it.
It will stop it as the trust, if they carry on with the trust. They might decide to take all of their assets out of the trust and, be unprotected again. But if they keep it in the trust...
That would be a choice, which they are making for a reason, presumably,
absolutely.
At that time.
Yeah.
Do you find when you're going to see customers that they're educated on this stuff, or you happen to educate them in the initial meeting?
It's a mixture. It really is. Google's I want a trust. Apparently, it will stop my inheritance tax.
It's a double-edged sword, Google, isn't it?
Yeah, absolutely. It's the old saying: a little bit of information can be
dangerous,
very dangerous. Yeah,
especially if you act upon it without full knowledge.
Yeah. Yeah.
What are the common questions you get, I guess, around inheritance tax? Is that the biggest
how
one?
can I mitigate it? What can I do to... And there are things, as you know, obviously, as accountants, and there's a certain amount I can do from the estate planning point of view. But there's also stuff which I would say, well, you need to be looking at doing more than just estate planning. You need to be looking at financial services. So
fine.
And that's where the networking comes in as well. There's... I get a good few referrals every single week from financial advisors, and the amount of clients I see with assets over £1 million and they haven't got a financial advisor. Or they have, but they just haven't heard from him in several years.
That's not just sort of a rule of thumb. I mean, it's just a fact that £1 million plus, everybody should be doing some form.
Oh, absolutely, yeah.
Because if we work out of the county of opportunity, and I'd say most people living in Hertfordshire, their principal asset will be £1 million or plus.
Yeah.
And I would think most people of our sort of age are probably looking to have 300,000, 400,000, 500,000 of other assets. So in that situation, where does the planning kick in?
For anything over £1 million?
Yeah, so say there's the average estate of a client of ours is 1.5 million, £1 million of property, £500,000 of other stuff.
Right, so you're saying
what would the next step be in terms of planning that you can offer?
Okay, so with the nil rate bands, residence nil rate band added to it, as long as it's going to direct descendants, children or grandchildren, then as long as everything's claimed for, we can look at £1 million being saved from tax. But in your scenario, there's still £500,000 there, which A lot of that is going to go to the government if they don't do anything. We can do some gifting, we can do some charitable donations, but outside of that, it really comes into the realms of financial services, which is a completely different regulations, if you like.
Yeah.
So obviously I can't advise on something like business property relief bonds, for example. I can make people aware of them, and I can point them in the right direction to do some inheritance tax planning under the financial services side.
With an IFA or
yes,
or similar.
absolutely, yeah. Yeah.
Nice. I've got a niche question, because we're finding more and more people that are having crypto assets. How does that work in terms of, does it go on a will? Can you give power of attorney to these wallets and things like that? Does it work similar to?
Good question. Yes, it's something that comes up more and more often these days.
I'd imagine so. Yeah.
we would include crypto assets in a will, obviously, and when drafting a lasting power of attorney, we can give the attorneys the right to use online bank accounts and crypto wallets, etc. As long as the client wants that, then yes, that can be written in there as special instructions, if you like.
Right. And do you have to place a value when you do a will, or is there anything where you have to place a certain value on the property or the cash?
I would do an estate valuation, but that's not necessarily going to go into the will or the lasting power of attorney, because obviously it's going to vary over the years.
Yeah, of course.
I can only give advice as to what their assets are at the time. They could go up or down, hopefully up, but could go down as well.
Yeah. Be interesting to try and see some of them exchanges getting a power of attorney for swapping over assets, just because it's difficult.
Well, one of the practical things I found is that you're not always aware of all the assets. There used to be you could write to a centralised sort of government resource, and it would distribute your request to all the banks that they have on their register, and you may get one coming back that you've never heard of, that you weren't aware of.
Yeah.
But with crypto, it's like good luck, right? I mean, there is no joined up single point, right? You've got exchange after exchange, you've got issuers, you've got 20, 30, 50,000 coins and equivalents out there.
Can you still do that with the banks, though? Can you write to a central point and say...
It is more centralised than it used to be, yes.
Right, okay.
Both for reporting the death and for the collection of assets and that sort of thing.
Really? I would have thought it was all... That would have been so difficult, just because we deal with banks.
Yeah.
So we've got so many clients here.
It could be better, but it is better than it used to be.
Yeah, we deal with, not all banks are equal. Some are more equal than others. But, the banks, the financial institutions, the insurance companies all subscribe to this secret database called CFAS, right, which has from time to time given issues to some of our clients. But the corollary of that would be that implies there is that central database hanging out the back. So any disagreement with Bank A will be informed and known by any other banks you have. And we've seen that element of contagion sweep through clients' accounts who may have 3 or 4 bank accounts. They may have created one receipt without providing sufficient info for that bank, and then the next thing they know, the other banks are falling like dominoes and closing their accounts, which infers a central sharing of information. But I don't know if that's available in a sort of probate context.
It is. As I say, it's easier than it was. I tend to do the front end of the probate cases,
right,
which is getting as much information that the next of kin or the executors know. Yeah. But yeah, there's other methods of investigating afterwards, and it's not always easy to find everything. Yeah, especially as you mentioned crypto. It's
well, my father was on one end of the scale, my mother on the other. My mother was organised and left me a spreadsheet. Nice. which had sort of the 10 or 12 things on it, so I was able to be fairly confident that I was carrying out her wishes to the best. My dad, on the other hand, was, you don't pay no inheritance tax when you're dead, blah blah blah. So I never really knew what was going on there, and so I did it on a best efforts basis. But there's always been a thing at the back of my mind that there was 1 or 2 things that never got swept up, and then they just revert, right, over time if there's no claim on a dead person's bank account.
I think there's a certain amount of time where you're still going to be liable for anything if you're if you're the executor or if you're administering the estates, then you have to be prepared to, well, just do the best you can. And if you've done everything you can, and you've recorded the fact that you've done everything you can, then things should be okay.
Yeah. In an estate planning situation or an estate, realisation situation, are there any complications that surround pension pots? So if somebody dies, because you often read in the paper, such and such is chief exec of whatever, had a pension pot of 3 million. That's an asset, presumably, on death?
It will be from after the last budget.
But does it depend how that's treated? Is it complicated to take ownership as a beneficiary of a pension pot, or are there rules?
There's still spousal exemption. So if it's going from husband to wife or vice versa, then there's no tax implication at all. But after the last budget, we now know that pension pots are going to be classed as taxable when it comes to probate.
Right.
So it's April 27, I think, 6th of April 27. Is it 26 or 27? One of the two.
So at the moment, if Mark's got a pension pot of £1 million and he dies tomorrow, that would pass to what? To a partner or to anyone named in a will, or would it depend on the holder of the pension?
It should be a named beneficiary of the
pot.
Of the pot, yeah.
Right.
The actual plan.
Do you have to inform the pension company of something like that, or
I would have thought you'd done that when you took it out.
You do, but
you'd put a named beneficiary down there, which is usually your spouse.
Yeah.
But sometimes,
and then children could be reserve beneficiaries or even main beneficiaries. But with it being children, come April 2027, thanks to what they've done in the budget, that will now be taxable.
Wow. That one had passed me by.
I heard the talk about that one.
Well, you've got the two big things in the last budget were family farm tax or family business tax. Because traditionally anything over 2 years, a business being passed to direct descendants was tax-free. Now, if it's over $1 million, it's going to be taxed at 20%, which is why we're seeing all the tractor convoys going through London. But the other thing was taxing pensions, bringing them into the actual taxable estates. And we're not sure how they're going to administer it. The advice at the moment is do nothing, because there is nothing that can be done.
I remember
yet.
at the time back in October, or leading up to October, people were talking about that. But then when the budget came out, I remember hearing commentators saying it's too complicated for them to implement quickly. And therefore
which is why it's been put back.
So why they've kicked it away for a couple of years.
And personally, I think it will be kicked further down the road come April 27, hopefully. But if it does come in, if they have worked out how to administer it, we have to remember that there's still spousal exemption, so it's not going to affect anything going to a spouse or a civil partner, but it will be taxable when it goes down to the children. I think one of the main things is, and you'll probably see this in accountancy as well, pensions will be used for what they was originally intended, an income in retirement, rather than a savings plan or a means of avoiding or mitigating inheritance tax.
I find it all a little bit daunting in terms of, it's probably coming for everything and everything and everything.
Oh, definitely. It's
that last comment was interesting, though, when you say the traditional view of a pension, income when you start working.
Yeah.
Rather than like a collection of wealth that you can.
Well,
pull
people
some
have
cash
used.
out.
Yeah, people have used it as a means of saving, of tax-free saving or tax-efficient saving, and also as a form of, inheritance tax planning.
Yeah, and in the sense that you can put into a qualifying pension, get various reliefs, and then past a certain age, you can pull a certain percentage of that out pretty much tax-free, right?
That's right, yeah.
So that's the kind of mechanism you're talking about there.
Yeah. Whereas, now that it's going to form part of your taxable estates, now I think it's going to be more back to the traditional, this is what I'm doing for my retirement.
Yeah.
Yeah, because people, I guess, were planning on just passing that down to family.
Or just taking it cash.
Well, they could take that lump sum and then pass the rest down a bit. I'm guessing.
Yeah.
Yeah, there's a big
So
change.
it'll be interesting to see what happens, whether they do actually go through with this. It could well be that they kick the can further and further down the road, and we'll end up with another government, which...
I was going to say, until they get kicked out.
Yeah. Yeah.
Hopefully. Fingers crossed.
Are you finding lots of people have investment properties as well? Because we're finding that's reducing. Obviously, the budget and all the taxes have meant they don't really want people to have second homes. But are you still seeing that as an asset on lots of people's?
I would say probably a third of the clients I see have additional property.
Right, okay.
Sometimes here, sometimes overseas.
That's a lot, yeah. Yeah, we're seeing it. We're definitely seeing a reduction.
Yeah.
Because, well, you think about it, the rent goes on top of someone's salary who's, let's say they're on 100,000. They're hitting that top rate, paying high rate tax on it, and you're really being burnt. People are putting it into limited companies, but if you've only got one, it's not really. It's difficult.
It's not my area of expertise, but from what I understand, the last few budgets for any government have been hitting buy-to-let portfolios quite hard.
I think what is interesting with what you say is giving us information like that. Like you see it maybe 1 in 3 times. That to me is quite surprising, because that's what you're actually seeing. This is actually what people have. This is actually the problems that people are going to need to deal with. So it's very useful, that information.
Yeah.
What about business owners? You got some to myself, Richard, owner-managed businesses. In terms of putting that into a will and stuff like that, how does that kind of work? Do you just sign your shares over to your missus or
Nearest and dearest?
It's part of your estate, so unless you actually name it specifically, it's all going to go as the residue, which is probably going to be to the spouse, and then on the second level of residue down to the children. But it also depends on the company as well. Most limited companies are off the shelf, so the death clause in the Articles of Association might be sort of non-existent. But it depends on how the shares are, and we often get asked to disperse of business assets in a will.
Yeah, but I mean,
they should be mentioned.
Yeah,
we're being asked more to get shareholder agreements and change.
Yeah, and we do have, we as a company, don't we? We take IFA advice, and we've had 1 or 2 things that we have done, but you're never really aware of everything.
Not really.
And I think that's where this planning element is very important, because why would you be aware of everything you can do?
Well, until someone we work with, legal practice, they were 2 partners, and he died suddenly. And to see what he's gone through, it really does make you start thinking. Like Keyman Insurance, he's a partner, and he's had to recruit 3 high-paying people to replace that partner's work, of which he's had no insurance to help with that, and it's really set the business back. Plus, he's got to find cash to pay the loved ones of the guy who died. And you really, until that's happened, and he's a solicitor, he bleeds out all this information on what you should do, shareholder agreements and all this insurance, but you sometimes don't get around to doing it for yourself. And
that's it.
And then it's like the power of attorney.
Yeah.
Very similar.
Yeah.
But yeah, when you see someone go through that, it really does. We know this guy really well, but
and no one really should have a business without having a lasting power of attorney set up. Some of my clients will have separate powers of attorney just purely for their business, so we'll call it a business LPA.
Right.
And some people are quite happy for whoever they've nominated as attorneys in their personal property and financial affairs LPA, that can cover their business as well.
We're going to have to get separate flights to Saudi now, just to protect us.
Be like royalty.
Well, we've got a couple of things in place, but I don't think we've got everything in place.
No, we definitely don't.
It's like, the lasting power of attorney, I think there might be an element of it in that thing we did with, the wealth managers.
Oh, right, okay.
But
you just don't know.
You don't know until it's too late sometimes.
Because you're just stuck into your business and working that you don't think about these things,
Where we were coming from more, our business is worth 10, whatevers. And, if I die tomorrow, it'd be nice to think that who I leave behind has, part of that 10, And so we've done something that triggers, and it effectively takes the spouse and family away from Cubed, because Cubed needs to carry on
Yeah.
being managed by people who know what they're doing, rather than having a potential spouse or a child that starts interfering. So we've done it really for continuity.
Yeah.
But one of the elements you touched on there, which was like key man insurance.
Yeah.
It's like, replacing someone with the sort of outgoing business development skills of Mark is not going to be done with one person. It's a good point you make about the solicitors.
Yeah, three
that was
people.
The case. Yeah.
3 people that well over 100 grand each. That's a massive hit, because that person, it's difficult for them to say this particular partner would have worked 7 till 7, let's say. No, trying to get someone on a salary to work 7 till 7.
You probably can, but it won't be the salary we're on.
No. No. But
So key man insurance would have covered
all
the
that
cost of doing that.
Yeah, and you can set that level, so you can estimate that actually I'm going to need someone who can do this, that, and another person who can do that and this, and then all of a sudden you've got the number.
Yeah.
And then you can protect it maybe for 12 months. Or,
it's again, we give that advice to clients.
Yeah.
And, this solicitor gives that advice, but you just don't get it.
So again, the key man insurance would come from financial services. So,
yeah.
So it's the three sort of sections dovetailing there, isn't it? Estate planning, accountancy, and financial advice.
Because the thing we've got is
all wrapped up with some friendly lawyers.
Is a cross guarantee or something like that. But I'm guessing that would go on the will, right? If we've got a cross guarantee that gives X amount to a partner, would that go on your will?
Not necessarily,
No.
I wouldn't have thought. But what sort of agreement would this be?
So it's, if Richard passed away, I would, the company, or me, the
He
company...
looked really sad then when he said that, didn't he?
The company would owe Richard's partner a certain figure.
Right.
But I'm not sure whether that would go... Because I guess the liability sits with the company, maybe.
I think that would be like, death benefit and a pension or something.
Yeah, it is. It's
It
basically
wouldn't actually
what happens. It triggers something.
come into the estate,
and
That's
half
right.
a million
It would
quid
bypass it,
money
surely.
comes in, and then it's intended to go there,
Yeah.
and that's kind of how it's written.
Right.
So that will trigger this. That comes in. That effectively remunerates, because effectively she would inherit. That's Hazel, by the way. She would inherit, 50% of Cubed, which is just a private limited company, which has no market in its shares, and therefore, what is that value? So we've effectively got an agreement where we revalue the business every 3 years.
Right.
Define that value, and then that will trigger a payment of that amount to effectively buy back the shares from the spouse. So it's all kind of simultaneous.
Yeah.
So it effectively means that an outside policy buys back the shares for Mark, effectively, in that situation.
Yeah.
So he then can carry on, hasn't got to find some money out of the business because it's all tied up, and push it over there, which is the issue you made there about the lawyers. He was doing both simultaneously.
That's right.
At least we got one thing covered.
Yeah.
Yeah, it's tough.
Enough about us.
Yeah. In terms of just advice, and what would you give to the people that are listening today in terms of, reaching out to you first?
We offer free advice. If someone rings up, they don't get charged for any advice we give. Any consultations are free of charge.
Nice.
Cup of tea and a biscuit is always welcome. But
And a consultation would typically just scribble on the back of a fact packet roughly what the estate looks like today, and then advise.
It's a little bit more than a fact packet. It's quite a nice instruction form where I get the information.
So it's data collection ahead of any meeting?
No, that would be at the meeting, though sometimes I get quite a lot of information on the phone initially or by email. But at the meeting, technically, I'm not supposed to give any advice until I've got the information down. So I always start by writing down the basics, even though probably 90% or more of the time I know what the advice is likely to be anyway, just from the initial phone call.
Yeah, nice. And what's the future plans for the company?
Future plans are to steadily increase growth. The drafting side is being subbed out to another company, who also, members of professional bodies with the relevant insurance policies, of course. And there's going to be an announcement very shortly about collaboration with 2 local charities. So
Very good.
One's the Thin Blue Paw, which is sort of pensions for police dogs.
Nice.
Police dogs don't get anything, when they retire, that's it. They're sort of just cast adrift. And there's been a couple of cases in the national press about dogs that have been injured on duty, very badly wounded, and rather than spend several £1,000s on vets bills, they've taken the option of euthanasia. Which
several thousand sounds cheap.
It's
You're
probably
talking
a lot,
on
tens of thousands.
Yeah. I didn't know that charity.
Yeah.
What was that charity again?
The Thin Blue Paw.
It's Kieran's, Liam's brother.
That's his charity.
Yeah.
Yeah.
Yeah, it's great. Some of the stories.
And the other charity is In Sue's Name, which is been run by a chap called David Taylor for several years now. He lost his daughter to a brain tumour. She was only in her 40s. He has worked tirelessly to keep her memory alive and raise money for brain cancer charities. The chap's in his 80s now, yet he's jumped out of aeroplanes. He's done wing walking. He's organised sponsored walks and events. And
nice.
Yeah, it's just a good charity.
In Sue's Name. That's
In
the
Sue's
charity.
Name.
The daughter, right?
Yeah. That was his daughter, yeah.
Nice.
And the tie-up, how does that tie-up work? It's to try and encourage people.
It's going to make
put
them
something in their will towards
they
the
are
charities?
going to publicise Bish estate planning or will writing in general. Asking for donations, legacies in wills on their websites, etc.
Because you do see a lot of adverts now for the larger charities, don't you? Like, say some of the the bigger charities, and Cancer UK, I know, have a lot of TV ads. Almost not coercing is the wrong word, but saying, "Have you thought about?" What is there a benefit other than feeling good in your death about a charitable donation?
Yeah. Charitable legacies are not taxed. So it will bring your total taxable estate down. I think you need to give 10% to make any real difference, but basically it brings it down from 40% to 37.5. So it's another form of tax planning and making yourself feel good at the same time.
So you say that the actual rate changes if you make a significant charitable donation?
A significant amount. It's quite complicated the way it works, but it is a form of inheritance tax planning. Yeah, charitable gifting.
Wow, I never knew that at all.
That's really cool.
Oh, you'll be on Google later on.
Yeah.
No, I'm going to be signing my direct debit up to the police dog charity.
Yeah. Well, the announcement is shortly to take place, but we're going to be donating a minimum of £20 from every single case to one or other of the charities.
Nice.
So it will be the client's decision which one. If they don't decide, then I'll just try and even it out at the end of each month.
Yeah. That's great. That's perfect.
Well, we should definitely put those on our proposal.
Yes, add them on, yeah.
Because we have that on our standard proposal.
Right.
When we send that to a client, it has a charitable donation, yes, no, at the bottom, where it lists about half a dozen charities, or Cubed's Charitable Foundation. So we
should add that on.
Oh, great stuff.
Yeah, because it's local. They're both local.
Yeah. Well, the organisers are local.
Yeah.
Nice.
But I mean, they'll cover for police dogs, for example, all over the country.
Yeah, obviously, yeah.
Great. We'll sign it off, I guess. I'm going to let you sign it off.
There's no pension element in there in terms of when you do your planning. Because I don't want to labour a point, but if you've got a pension pot that's worth X, does that always feature potentially in a will situation?
Never used to.
No.
Always used to.
Well, that's likely.
We would try and make sure that any pension pot bypassed the estate and went directly to named beneficiaries. But since the announcement in last year's budget, then now that's not looking likely.
And at the moment, that
it's still tax-free at the moment.
The moving it to the named beneficiary, that's without limit, is it?
Oh, at the moment, yes.
Yeah, right.
Yeah, but come April 2027, they plan to tax that at 40%.
Well, in that case, thanks very much for all that. Those words of wisdom. There's 2 or 3. Every day's a school day, as we say.
Yeah, a couple of nuggets for you.
More than a couple, Stephen. Thanks very much for spending the time.
Thanks for inviting me.
I hope the questions weren't too dumb, but I think there's a lot of ignorance
Too
out
dumb,
there.
too difficult, maybe.
Yeah.
Thanks, Steve. Thank you.
Thank you.